The balance of power shifts in the United States Senate, plus an interview with Gun Owners of America's Sam Paredes on their lawsuit against Oregon's new gun control law. That and more on this episode of the Weekly Reload Podcast.
I made the devil run. I gave him poison just for fun.
All right, welcome, ladies and gentlemen, to another episode of the Weekly Reload Podcast. I'm your host, Stephen Gutowski. I'm also the founder of thereload.com, where you can head over and sign up for our free newsletter today if you want to get access to weekly updates on the latest in gun news around the country. This week, we are going to be talking about what's going on in Oregon as sort of the epicenter of gun news in America right now, because they passed a ballot initiative recently that's led to all kinds of chaos there, which we will be discussing with Gun Owners of America board member, Sam Paredes. How are you doing, Sam?
Stephen, I'm doing just great. It's an honor and a pleasure to be here with you. So ready to talk about what's happening up in Oregon. Yeah,
and can you tell people just a little bit more about yourself and how you're involved in this case as well?
Sure. First of all, I'm Executive Director of Gun Owners of California and a member of the Board of Directors of Gun Owners of America and Secretary Treasurer of the Board of Directors of Gun Owners Foundation. And that is our legal arm. That is the group that we use to file our lawsuits and our amicus briefs. So very, very heavily involved in the whole Gun Owners of America network.
Mm-hmm. And you guys have a lawsuit at the state level right now in Oregon, and you're also supporting a lawsuit, I believe, at the federal level. There's 4 different lawsuits at the federal level against this new ballot initiative, but you guys are part of this legal action at both levels, and you've had success at the state level, right, so far?
Yes, there have been 3 lawsuits filed in federal court on Second Amendment issues. We are supporting the OFF, the Oregon Firearms Freedom lawsuit. We submitted an amicus brief in that lawsuit, and then we filed a different lawsuit in state court. And we did that because the state of Oregon has a Second Amendment clause in their constitution. And we believe that Measure 114 was in violation of their own constitution, and thought that it was meritorious that we pursue that angle.
Right. And so just to give a little background to everybody right now, this ballot initiative passed about a month ago with a very thin margin. It was about 50.7% in favor, and it institutes a new permit to purchase system that has a number of new requirements, like a state mandated firearms training and processing fee, fingerprinting, a state background check in addition to the federal background check. There's a number of things that you have to obtain before you can actually get this permit, before you can actually buy any guns. And the big issue with that is that it was set to go into effect 30 days after the vote was held, which of course would have been on December 8th, Thursday, before this. It's actually today, the day we're recording this, but obviously the podcast comes out on Sunday and Monday. So, but the problem was that there was no permitting system. These systems didn't exist, and the state wasn't able to spin them up in time to comply with what the law said. And so effectively, had this ballot initiative gone into law and been enforced, it would have made all gun sales in the state completely illegal, right? I mean, that's not an exaggeration, is it?
Not at all. That is not an exaggeration at all. And to prove that point, the state went begging to the federal court to allow them to continue to sell guns, but ask that people fill out the registration forms, even though there's no registration system in place for them to be able to process them. They knew that the infrastructure for the background checks and the registration system and the details on the all of the requirements that are within 114 were not in place. They did not exist. They still don't exist as far as we can tell. And so the leadership in Oregon found that they were way behind
Yeah.
on this thing and had to come up with something. So they begged the court for assistance. And
Right. So the state itself, the Attorney General's office that's defending this law in court, and they still argue that the law is constitutional and the underlying provisions are, should be upheld. But even they admitted that there was no way they could possibly comply with the timeline that was put in place. And so, they asked the federal judge to delay the implementation, which they got. But in your case, in the state side, the judge there actually issued a much broader ruling and blocked the entirety of Measure 114, right? I mean, because there's the permit to purchase law. There's also a magazine ban in this ballot initiative that makes it illegal to make or sell or transfer magazines that hold more than 10 rounds, right? And it even limits the ones that you already own in a large degree as well, too.
Yeah, we decided that since the Oregon Constitution had a provision of the Second Amendment analogous to the Second Amendment to the federal Constitution, the Bill of Rights, that this was the place where we should pursue, legal protection. And in doing so, the judge who heard the case, we requested a temporary restraining order. And the temporary restraining order is asking the judge to suspend the entire law, not any provisions of it, but the entire law. Now, when a judge considers a request for a temporary restraining order, there are two factors. Number one, that the people that are affected are actually injured. There is a detrimental impact on the people that are affected by the law. Secondly, that there is a great chance that we, the people who are bringing the lawsuit, are going to succeed in the long run. In which case, the judge decided, we, based on the merits of our case and our arguments, that we have a very good chance that we're going to win in court. Therefore, the judge issued a temporary restraining order. With the next Tuesday, there will be a hearing where they will consider an injunction, a temporary injunction. What the injunction does is it suspends the law for the entirety of the legal process. While this case goes through the legal process, the temporary restraining order suspends it until the date of the hearing. So it's convoluted and complicated, but that's what the situation is right now.
Right. So currently, this law is not going to be enforced because of the state court ruling. Just to be crystal clear for everybody in Oregon, this law will not go into effect as things stand right now, today.
You are absolutely correct. As of today, the law is not being enforced, and Oregonians are taking advantage of this time right now and are lining around the corner of virtually every gun store in the state, trying to buy all of the guns and ammunition and magazines that they can possibly get because they're concerned that this law may go into effect. But as of right now, the law is not in effect.
And the next hearing is going to be on Tuesday.
Correct.
And that'll be for the preliminary injunction, which is a more permanent order than a temporary restraining order, right?
That is correct.
Okay. And in fact, the Attorney General in Oregon, who's a Democrat there, they attempted to have the state Supreme Court intervene in this case and force the lower court judge to rescind this temporary restraining order, right? But that failed. That's my understanding. Is that correct?
Yes. A very pleasant surprise is that the Supreme Court upheld the temporary restraining order issued by the lower court. And they basically solidified the fact that this law is not going into effect. That is a huge victory for the rights of Oregonians in their ability to exercise their right to keep and bear arms, to purchase, to keep, and to use firearms for lawful purposes. So, yeah, that is there's no place else for them to go unless they want to appeal the ruling of the Supreme Court all the way to the United States Supreme Court, which is the only other option they have, and I don't think they're going to do that.
That's interesting. So for people outside of Oregon or who don't really understand the state court system there, perfectly. Can you give a little more insight into why you think that's both a surprise and so significant? What, why was this such a big deal that the Supreme Court denied this request?
Well, there's no secret that Oregon politically tends to lean to the left. That is reflected in their court system. But I think the importance of this is that the courts are looking at what happened in the New York State Rifle and Pistol Association v. Bruin decision by the United States Supreme Court, and are realizing that, golly, if we go ahead and lift the temporary restraining order and then find out that we're going to have to follow what the Supreme Court said and we're going to lose, that's not a good situation for us to be in. Judges don't like to be wrong. Make no bones about it. A judge who issues a decision, even though it's a politically motivated decision, they still don't like to be wrong. And that's why they go into all of these explanations as to why they decided the way they did, interpreting the Second Amendment and the Constitution the way they do in order to try to, not be wrong. And I think in this case, we're finding that the judges are being realistic and understanding how they are going to have to rule with regards to Second Amendment cases across the board.
Interesting. Interesting. So you think the Oregon Supreme Court was concerned that if they did force this lower court judge to go back on his ruling, that perhaps the United States Supreme Court would step in and overrule them, and they don't necessarily want that to happen.
Well, I think what will happen is that had they lifted the temporary restraining order, and then next Tuesday when we have the hearings on in the federal cases and the state cases, there was I'd say little chance of making an error if they left the TRO in place. This is just supposition on our part as we have watched the courts in Oregon and the political directions that the state has gone in. So we are surmising that these are the situations, and my guess as a very interested observer is that the courts don't want to be wrong on this thing, and they have very little to give up by not lifting the TRO and waiting until next Tuesday to see what happens.
Yeah, and we'll get more into the federal court case in a moment here, because that judge did come to a different conclusion ultimately than the judge in your state case. But first, I want to talk a little bit more about what the judge held in that state case, because he ruled from the bench, right? So we don't have as much to go on in terms of a written opinion. We have a little bit, where he talks about how the plaintiffs showed enough evidence to prove that you were irreparably harmed and that this is a violation of your constitutional rights under the Oregon state constitution, which, as you mentioned earlier, has basically a almost identical right to keep and bear arms protection as the federal constitution does. It's slightly different, but it's effectively the same language. And so that was his reason for enjoining or temporarily restraining the entire law, because even a limited time deprivation of somebody's rights is not acceptable, as paraphrasing what he said here. But can you give us a little more insight maybe to what he was saying in court for how he reached those conclusions? Well,
this case is not just about the Measure 114. It has to take into account what happened as far back as Heller versus Washington, D.C., and then McDonald versus Chicago, as well as New York State Rifle and Pistol Association versus Bruin, because that kind of set the stage that the right to keep and bear arms is an individual right, that it is incorporated into the states, meaning that states and local governments cannot infringe on that right, And then the Bruin decision gave us the process for which courts are allowed to evaluate cases around the Second Amendment. In the past, state and local courts and even federal courts would use a two-step process to evaluate whether the issue at hand violates the Second Amendment. And then if it does, whether there's a government interest that will override the infringement that is being foisted on the citizens of the country or the state or the locality, in which case that is the rationale that they have used to justify and allow all manner of gun control to exist throughout the country from sea to shining sea. So the court said, no, the two-step process is one step too many. If it infringes on the Second Amendment, it is unconstitutional. And if you and they didn't give them a blank check, but they also said they said that it doesn't give you the ability to do anything you want. If you pass a law, there has to be an analog to the law that you are passing now to 1791, when the Second Amendment was ratified, not from 1791 to 2022. At the time of the signing, there has to be a historical analog. And if there isn't, by definition, the law is unconstitutional. And everything in Measure 117 falls under the category of there being no analog. There were no background checks required. There were no fees required. There were, no, all of the provisions, bans on magazines. None of these things existed back then. So therefore, by definition, at the foundation, they are unconstitutional. And I think that the judges are looking at that. I hope that they are, and realizing that, well, you know what? There's the preponderance of logic is that Measure 114 is unconstitutional, and as has been stated throughout our legal system, that justice delayed is justice denied, and they are taking the proper steps to ensure that the rights of Oregonians are protected until this issue is resolved in the courts from start to finish, and that's a beautiful thing.
Right. I think you gave a pretty good summation of at least how a lot of gun rights advocates view the Bruin ruling, and it seems like that's what Judge Ruscio. I hope I don't mispronounce his name.
Don't ask me to butcher it. I like the judge.
This is the judge. He's in Harney County,
right.
Oregon, and it seems, reading some of the quotes from what was issued, the written part of the ruling, that it's in line with what you're describing here, especially in regards to the magazine ban. For instance, he writes, absent entry of this temporary restraining orders, plaintiffs will be deprived of their right to bear arms pursuant to Oregon Constitution Article 1, Section 27, by being made unable to lawfully purchase a firearm or bear a magazine of holding more than 10 rounds of ammunition in the state of Oregon. Deprivation of fundamental constitutional rights for any period constitutes irreparable harm. And then later he says, the plaintiffs are persuasive that magazines are protected by the Oregon Constitution, and firearms containing fixed magazines that can hold 10 bullets or more are in common use within Oregon, which obviously alludes to the Heller decision, which found that handguns could not be banned by Washington, D.C. because they were in common use for lawful purposes. Mm-hmm. And he's fairly clear in the written order on those points. But I was just wondering if there's any further insight on, that he might have said from the bench during the ruling in regards to like the permit to purchase laws you were articulating there. The argument against it is that there was no historical analog for that sort of regulation at the time of the founding, or really for long periods after that. But is that something he actually directly said in court?
I didn't see that he said that. I think that this judge took a measured and cautious and proper position on the challenge to Measure 114. There was very little. I didn't sense any sort of a political bent or anything like that. It was a judge doing a good judicial work, taking into account the arguments that were made by our case and the references that were made to what the law is across the land, the law of the land. And the judge saw merit in our arguments and chose to issue this temporary restraining order. Now that doesn't guarantee.
And you guys,
what's that?
You explicitly argued that about Measure 114, that for instance, the permit to purchase law,
yes,
it doesn't have a historical analog and is therefore unconstitutional under Bruin. That was your basic argument here.
That was part of the entire argument. Yes, pointing out all of the problems, the lack of historical analog, and the fact that the fact of the matter is, Stephen, that even the voters cannot vote away a enumerated constitutional right. There is a process for changing the Constitution, and it is not by a referendum vote in a state or the passage of a law by the legislature or even Congress. You cannot vote away those rights. And I think that is sitting more at the forefront of the minds of judges who are considering some of these issues. And, in other cases throughout the country, we know that judges have, in anguish, had to comply with the Heller, McDonald, New York, Bruin decisions and the direction that the Supreme Court has given them. But this was not a tortured decision. It was measured. It was logical. And I think that the judge did a really good job of considering what the law of the land is and what it is that they did in the state of Oregon with Measure 114.
Okay. I think that dovetails well with where I want to go next, which is the federal ruling is that we have thus far from the district court, which kind of came down the opposite side of these arguments. This is a judge who denied the request for a temporary restraining order from this your guys' state affiliate in this particular case. And while she did delay the implementation of the permit to purchase requirement because the state had asked for that, and there was no way to that they were going to be able to have a permitting system up in time. I still, frankly, doubt that they will have one up within 30 days either. Mm-hmm. But I don't think another month is going to get them across that line. But we'll see. She basically did what I think a pretty broad and fair way of characterizing is she did what the state had asked her to do, which is delay implementation of the permitting law, but don't issue a temporary restraining order against the entire, the underlying provisions. And she, of course, wrote an entire written ruling that explained more of her reasoning. And I think it came down to a couple key points, right? So where Judge Riccio, I hope I got his name correct there, where he argued that the magazine ban is a violation of Oregon's right to keep and bear arms amendment because those magazines are in common use. Obviously, you and I know, and most gun owners are aware that magazines that hold more than 10 rounds of ammunition are standard in all modern firearms that accept magazines, essentially. They really come with basically every handgun and rifle that accepts a magazine. They'll come with magazines that hold more than 10 rounds. There's billions of these kinds of magazines out there in the country, presumably. And surely Oregon is not an exception to that. It never had a magazine ban before this. So, that's where his conclusion was. Whereas the federal judge, which is Judge Karen Immergut, she ruled instead that those magazines may not be protected by the Second Amendment. Here's a quote from her ruling. Plaintiffs have not shown that the magazines restricted by Measure 114 are necessary to the use of firearms for lawful purposes, such as self-defense. Therefore, plaintiffs have failed to show that magazines capable of accepting more than 10 rounds of ammunition are covered by the plain text of the Second Amendment. And then she also went on with describing the permit to purchase requirement in 114 as akin to a shall issue gun carry permitting scheme, and that it wouldn't necessarily violate the Second Amendment because there was concurrence in Bruin with Justices Roberts and Kavanaugh that talked about how shall issue permitting laws are not implicated in Bruin. And so she's comparing this permit to purchase regime to a shall issue gun carry permitting regime, and says, is concluding that they're likely constitutional. So she sort of came down on the opposite side of things from the state judge. And I'm wondering your take on her ruling and why you think she's incorrect. Let me just start with the magazine portion. What do you see as wrong with her reasoning there?
Well, Stephen, I believe that the federal judge in this case was really working very hard to go the long way around the barn to justify her ruling. I think that if you read the text of her decision, you will unavoidably come to the conclusion that she really did not understand the Bruin decision and other decisions, Caetano and Heller and McDonald and other rulings that the Supreme Court has given as to what constitutes a firearm or arm that is in popular use, and she didn't understand the directive given by the Supreme Court. I think that she parsed portions of the Bruin decision in trying to come up with logic that would allow the state to put prerequisites. Now, Bruin in particular was referring to concealed carry weapons permit licenses in the state of New York and therefore across the country. This is even more basic. This is the state giving its citizens permission by requiring them to go through steps in order to be allowed to exercise their constitutional right. That's a whole different animal. And I think that the federal judge will be found to be greatly in mistake in that interpretation. They choose to take small snippets of Justice Kavanaugh's and some of the other justices in previous decisions and in their commentary in Bruin, and try to use small portions of their opinions to justify what the state wants to do. For far too long, judges across the country have done everything they can to legitimize whatever the state wants to do. That's why they have utilized this two-step process, is because that is the way that they have justified all manner of gun control in states across the country. And I think that in this case, this judge has not gotten the message yet that is no longer allowed. And I think that the ruling in this case shows that front and center. Now, in this decision, the judge admits that there is a problem in the state that would be created if because there is no system to be able to comply with the law, that truly the core of the Second Amendment would be violated because it would take months for the state of Oregon to establish a system that would allow and give permission to people to buy firearms, and that it would be a clear and gross violation of the Second Amendment. Well, our belief is that the judge didn't go far enough in evaluating and using that logic to evaluate the rest of the of their decision. If
So,
go ahead,
just real quick here on the this idea that you're referencing the former two-step standard that federal courts had used to uphold a lot of gun laws after Heller and McDonald, and you're sort of comparing this district judge in Oregon's opinion to that, and I think that's interesting because she's essentially arguing for the magazine ban portion of this. That
correct.
Magazines are magazines that hold more than 10 rounds of ammunition are not required for the operation of a firearm, and so therefore they may not be covered by the core of the Second Amendment. That banning them doesn't implicate the Second Amendment really, because they're not wholly necessary for the use of firearms. What first, like, obviously I assume you disagree with that basic concept, just off the bat there.
Absolutely, 1,000%. First of all, you and I know that criminals will not abide by Measure 114 in Oregon or in any other state in the Union or the territories of the United States. They don't abide by any of these rules and regulations, and they will use whatever it is that they want to commit their crimes. These restrictions only apply to law-abiding citizens. And in applying these restrictions to law-abiding citizens who will maybe reluctantly follow the law because they are law-abiding citizens and they hate it, but they don't want to violate the law. That's why so many of them work to change these bad laws by supporting Gun Owners of America and all of the other organizations that are fighting to protect their rights. But the fact of the matter is, citizens throughout the country use firearms with standard capacity magazines, handguns that hold 17 rounds like the Glock 17 and 15 rounds like the Glock 19 and 12 rounds and 20 round magazines and 30 round magazines to protect themselves all the time. So what the promoters of this measure are okay with is that they are okay with those citizens who choose to use those firearms to defend themselves to go from successful survivors of crime, and they're okay with putting them potentially in the victims of crime. Because in Bruin, Justice Thomas pointed out that millions of people throughout the country every year use firearms to successfully defend themselves, oftentimes without ever having to fire a shot. But there are cases where shots have to be fired, and lawful citizens should be given every advantage that they possibly need. They should not be handicapped by these policymakers who are arbitrarily coming up with these numbers. Most people don't know that the number 10 came up here in California when they banned large capacity magazines, they call them. It was like, okay, guys, we're writing this legislation. How many rounds do we allow them? 1, 2, 3. Well, I ran out of fingers, so it's going to be 10. That's what we're going to limit it to. And that's how it came up. It was an arbitrary number. In New York, we know they tried to reduce that to 7.
7, yeah.
And so
other states have it at 15, of course. So yeah, I mean that certainly makes sense as the moral argument for why these bans are wrong. But what about the constitutional argument? Why is she wrong to say that these magazines aren't protected by the Second Amendment? They're outside the Second Amendment. Is it because they're so common and they're used for lawful purposes? Is that what you're sort of the gist of why these would be protected?
Yeah, that's a great question. And people, when you take into account the case in New York that had to do with the electronic tasers and things like that, where they were trying to control them.
Right.
And the court the Supreme Court held that those weapons were qualified as weapons in popular use and therefore protected by the Second Amendment. There's no secret that magazines are an essential part of the operation of semi-automatic firearms and even some bolt-action firearms. And since they are essential, they are considered the same as weapons, and they are in popular use. As you pointed out, there are hundreds of millions, if not potentially a billion magazines owned by people in the United States right now. So anybody who will try to argue that they are not in popular use for lawful purposes is just not being honest.
Yeah, right. That does seem in line with what the Supreme Court has held on both handguns and, as you were talking about with 2016's Sertano, stun guns as well. There are only a couple 100,000, I believe, in that case that they identified, but they still said that was common use, and there's way more magazines that hold more than 10 rounds out there than a couple 100,000. So, obviously there's not necessarily a number that the Supreme Court has put on it, but certainly it seems the most popular kind of magazine is one that holds more than 10 rounds, and so banning it, and then back to her argument on permit to purchase, where she says this is, here, let me give you a quote directly from her ruling. Measure 114's permit to purchase scheme is a shall issue permit scheme based on objective standards and is therefore presumptively constitutional under the holding of Bruin. I guess first point there, isn't there a provision in this ballot initiative that does give subjectivity to people issuing these permits? That, if they determine you're a threat to yourself or others, they can deny you a permit even if you haven't been convicted of anything or involuntarily committed?
Any of these schemes like Measure 114, there's no question that there is some level of subjectivity in the issuing of permits, the time frame with issuing the permits, the amount of money that's required in order to gain the permits. And if they can give permits, they can also take them away. So there is definitely a level of subjectivity from our perspective in the scheme that they have come up with. But for people who are trying to understand, well, what's wrong with requiring a permit to be able to purchase a firearm? Well, how about if the government said that you have to submit a form and become registered if you wanted to go to church? Or if reporters had to register before they went to work for some news agency and pay a fee and have a background check in order to exercise their First Amendment rights of freedom of speech and freedom of expression and freedom of religion, people would say that would be unconstitutional. Ding, 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 ding. It's the same thing with the Second Amendment. They are trying to say that we Americans, those of us who obey the law, are guilty until proven innocent. So, and that's not the way law works in America. We are innocent until proven guilty. And requiring us to go through all of these steps is just backwards. And we have to fight it here, because if they're successful with making these requirements on the Second Amendment, there's no question that they will be inching towards the First Amendment as well. And we see that in government's intrusion into the freedom of speech, whether it's social media, whether it's the news media, what you say, what is considered unconstitutionally protected speech. That is a dangerous path, and I think that that is where they're going with their restrictions on the Second Amendment and requiring people to prove that you are a law-abiding citizen before we're going to allow you to open your mouth and say something, or to obtain a firearm to use to protect your life, your family, your homes, and your businesses. You're going to have to prove to us, the government, before we allow you to exercise that right. So it's man, that's the dangerous waters that the courts are the policymakers and some of the judges in the court system that are treading on, and we need to be aware of that.
So that all makes certainly makes sense, but I guess my thought on this, or one area where I find her ruling interesting, is that the Supreme Court did, or at least that concurrence with Roberts and Kavanaugh does go into how they aren't questioning, shall issue gun carry permitting, even after they put gun carry on the same level as just gun ownership in terms of what's protected under the Second Amendment. And so, I wonder, assuming for a moment that Oregon can convince the court that the section that allows them to, deny permits based off of what appear to be more subjective measures, like whether the police think you're a danger to yourself or others based on something other than actual convictions or commitments that would come up in a background check. If they could convince the court that this was closer to a shall issue regime in permitting to purchase, I do wonder whether or not that will be viewed as in line with Bruin because of that concurrence. And I'm interested in why you think it wouldn't be.
Well, that's a great question, and I'll answer it like this. The Supreme Court in Bruin said that the Bruin decision is not a straitjacket on government policymakers to pass measures having to do with firearms, but it is also not a blank check. And then and the policymakers that are proposing these measures, like 114 in Oregon and other gun control measures that are popping up throughout the country, they stop at the comment from the court that it is not a straitjacket. It is not a prevention of these things. But the court also said that it's not a blank check. And then it gave the ability for people to evaluate whether it's permissible or not. They said any law that is being considered on the books now has to have a historical analog. So they said text as informed by history and tradition going back to 1791. If there was a law that existed at the time, then the law that is being considered now can be evaluated, whether it has that historical analog. If no historical analog exists, by definition, the law is unconstitutional.
Yep. The
people that are trying to promote more gun control hate that. They ignore the rest of that. They come up with all of these arguments. Well, they just use muskets and these kinds of things back in the day. How would they know? And well, you know what? The law of the land is very clear, and there's very little interpretation that's required in order to apply the standard that the Supreme Court issued. And every time that standard is violated, that measure is going to be taken to court, and that is exactly the case with Measure 114 in Oregon.
Okay, so essentially, just the idea is that that's the standard. You articulated the standard, I think, very well for what Bruin says you're supposed to do when judging a Second Amendment case, and that matters much more than dicta, basically all the other stuff that they wrote in concurrences or whatnot that just sort of gives more of their thoughts, but is not necessarily binding in terms of how you're supposed to judge these cases. Is that a good summation of what you're saying there?
Absolutely. And I think that's being born very clearly in that there have been multiple lawsuits, cases throughout the country since the Bruin decision, and judges, even though they've been appointed by Presidents Clinton and Obama and Biden, have ruled for the Second Amendment because of the new standard that they are required to use. And therefore, gun control measures throughout the country have fallen on the dung heap of legislative history as being invalid and a clear violation of the Second Amendment. So that is absolutely being borne true. And that we will keep finding these Energizer Bunny policymakers and judges who will try every way they can to get around the clear standard that is now set by the Bruin decision. And we will be prepared to fight them every step of the way.
All right. Well, thank you so much for joining us, Sam, and giving us insight into what you guys are doing with GOA and GOF up there in Oregon, and how this fight is progressing and what the next steps are. Tuesday is going to be an important date, it sounds like, for both of these cases. And I think it's going to be really interesting to see how either one of them turns out, because they seem to be headed in different directions. Although you really only have to win one of them, right?
That's correct. This is one of those situations where we win one, we win it all. And our hats off to our partners, Oregon Firearms Freedom, who are waging the fight, and we are supporting in their federal lawsuit, and to everybody who's been involved in fighting for freedom, whether you're a resident of Oregon or not. This issue is incredibly important to the restoration and the protection of the Second Amendment from sea to shining sea. So thank you for everybody who is engaged in this fight with us. And it's not over, but it's looking pretty good.
And where can people find out more about Gun Owners of America or Gun Owners Foundation if they want to keep up to date with your cases?
Super simple. Just go on the internet, gunowners.org, gunowners.org. Our website has information on all of the news. We often quote and report your reports, Stephen, on the GOA website. We have information on all of the court cases, press releases, alerts, information on what's happening in Congress, and links to Gun Owners Foundation if you want to financially support the legal effort to restore and then protect and defend your Second Amendment rights. We invite everybody to be involved. As Gun Owners of America is no compromise. We will accept no compromise with regards to the Second Amendment. That is our motto, and that is what we live by. So thank you very much for the opportunity to discuss these Measure 114, Stephen. It's a pleasure.
Thank you so much for joining us. We're going to head on over to our news update now. And we will hopefully have you back on when there's some more news for us to update on.
I would love to, man.
All right, ladies and gentlemen, it's time for the weekly news update. I'm contributing writer Jake Fogelman, joined by Reload founder Steve Gutowski. How you doing, Steve?
I'm doing good. How are you doing, Jake?
I'm doing all right. We had some final wrapping ups of the busy election season. It's finally over. It seems like it lasted forever. But the Georgia runoff, we had a final result, and incumbent Senator Raphael Warnock secured his reelection against Republican challenger Herschel Walker to, at the time at least, solidify a 51-49 split for Democrats. But just this morning, as we're recording, we actually have some breaking news that throws that, I guess, and throws that off a little bit. If you want to talk a little bit about what's going on in the Senate. Well,
so at first, I think just talk about that Georgia race real quick, just to wrap things up. We did the podcast last week, and on the podcast, we talked about how, guns weren't necessarily a large issue, leading issue in that race. It wasn't something that the candidates were focused on a lot, although the NRA certainly did get involved heavily in the race and spent, I think it's over $3 million, if I'm remembering correctly, whereas the gun control groups, I think, spent less than $100,000 combined. And so that was an interesting dynamic, but the outcome there is bad for gun rights advocates or gun rights activists because, well, for one, the NRA wildly outspent the gun control groups, so losing is not presumably not what they were going for. And two, although this one's going to change a little bit with the what we're going to talk about in a second, what's changed just recently here, but two, that it gives Democrats a larger majority to allow the president to appoint more judges. And obviously the president is staunchly in favor of stricter gun laws in the United States and generally appoints judges with that point of view as well. And so even though Democrats were going to have control of the Senate either way, this gives them a little more cushion in theory to push through some of these judicial appointments, as well as some of the executive branch appointments. Obviously, he's already filled the ATF position, but now any other position that may have an impact on gun policy that comes open, any of the law enforcement agencies in the federal government, for instance, or even places like Social Security, where the Obama administration tried to use executive rulemaking to add a lot of people from Social Security to the prohibited persons list or to the mixed background check system years ago and failed. Stuff like that, where you're trying to institute new gun restrictions through the executive branch, will be easier if you have the people in place that you want, and having a slightly larger majority in the Senate makes that easier to accomplish. However, Kyrsten Sinema out in Arizona, the Democrat, is no longer a Democrat, apparently. She has switched party affiliation, although not to the Republican Party, but to become an independent. Now, people who follow the Senate closely probably already know that she won't be the only independent. There are two other ones. Very famously, Bernie Sanders is technically an independent. And then, of course, Angus King in Maine is also technically an independent. It's not really clear yet how this is going to work out for Sinema. Obviously, in King and Sanders' case, they're basically just Democrats. They caucus with the Democrats. They vote with the Democrats in the vast majority of circumstances. If anything, they're maybe a little bit to the left of Democrats on a lot of issues. Although King did play an instrumental role in blocking President Biden's first ATF nominee. So, there's an example of how an independent perhaps had a significant role in this administration's gun policy in a way that maybe a Democratic senator wouldn't have done. I'm not sure that that's really the case. Usually in those situations where it was one person blocking something, it's usually there's a collection of senators who don't want that thing, and it's just one of them is the public face of it for that particular moment. But either way, it'll be very interesting to see how Sinema stacks up in all this, how she actually performs as a quote unquote independent, whether she caucuses with Democrats. I think to this point, she said she does not plan to caucus with the Democrats, but she does believe she's going to keep her committee assignments. And I'm not sure how that's going to work. So I don't know. What do you think? How does this affect the breakdown of the Senate in your mind?
I kind of agree with you. I think she'll play a similar role, at least from what she's saying so far. Obviously, this is still early stages, so things could get uglier down the road. But she said that she apparently is going to keep her committee seats. She said she plans to vote pretty similarly to how she has before. It's not like a wholesale change in her philosophy or anything. But I think she's been one of the more moderate senators, particularly on things like gun issues.
She voted for the bipartisan bill.
Right. She played a role in the bipartisan bill, but I don't think, for example, she's not like a cheerleader for an assault weapons ban when Biden calls for one, for example. So that's where I see her perhaps being more Angus King-ish with her new independence.
Perhaps.
Maybe more moderate stuff she'll be willing to throw her support behind, but could perhaps be a roadblock when it comes to bigger stuff like gun bans. But of course, it remains to be seen.
Yeah, absolutely. And I think, this is a pretty big shakeup in Washington. I'm not sure the last time. Usually, if you're an independent, you run as an independent.
Right.
So it's fairly significant that she went from a registered Democrat to a registered independent. That is a unusual move. Usually, the other thing that's usual in Washington, not that party switching is all that common, but generally you just go from one party to the other party. You don't make a stop in between to independent town. You generally, independents that make their way into the Senate or Congress do so by running that way as independents, and usually as an independent that is extremely closely aligned with one of the particular political parties. So I don't know. It's going to be interesting to watch what happens. I don't know. I don't know how this is going to affect Gun policy probably doesn't have that much effect. Maybe it has effect on the judges, depending on how, she perhaps will be more independent in how she votes on judges moving forward. I don't know. I don't think her record is blocking a lot of, judicial picks to this point. So probably not, but maybe, if she's trying to bolster her position as the sort of new maverick of Arizona or what have you, she might have to take more stands on practical votes, but maybe not. That's kind of been her thing to some degree already, slowing down the Biden agenda,
right?
And going against her own party. So I don't know. It'll be interesting to see. My guess is it doesn't have a huge impact on gun policy one way or the other, because she was already a marginally, a moderate Democrat when it came to gun policy. And it's probably the position she's going to stick with moving forward. And with Republicans taking control of the House, it's very unlikely you're going to see a lot of gun control measures make it to the Senate. They're not likely to be a very big issue in the next couple of years, just because they already did a gun bill. And I think a lot of senators view that as, something that they don't want to go back to again. But obviously events change things. As news events unfold, anything can happen. And certainly with a new 50-51 or what is it, 49-1-50, I guess now it was, if we're going by caucusing, that would be, I guess, the breakdown at this point.
Yeah.
And, how often is she going to side with the Republicans to do things, and how often is she going to side with Democrats? That'll be the big thing to watch for. And it'll probably have some effect on those appointments we discussed earlier. But that's not the only news we have for you today. As interesting as that development is, we also have some updates on the California fee shifting provision that's being challenged. This is where essentially California is copycatting Texas's abortion bounty law, right? And part of that was a provision where if you sue the state, in California's case, over guns, over their gun laws, and you don't win all of your claims, you will be responsible, and your lawyers too, for paying the legal fees of the state. Even if you've won on every claim except for a single one, you will still be responsible for paying the legal fees of the state. So even in cases where you prevail, the plaintiffs prevail, the state will receive payments for their legal fees. And so this is obviously a huge issue for gun litigation. It makes it far more difficult to actually sue the state. And so there's been a recent development, or two recent developments, I guess. You wrote about one at the end of last week. There's Judge Benitez, who's very well known for doing gun cases at the federal level out in California, right? He's involved in this legal fight now. Is that right?
Yeah. So he issued a ruling last Friday, basically saying that California had argued that this was a moot issue. So two gun rights groups filed suit against this fee shifting provision. And California's attorney general basically argued, I've publicly said I'm not going to enforce this fee shifting provision unless a separate judge overseeing the Texas law, the Texas abortion law, says that that's constitutional. So basically admitting it's a kind of a political play. And so the whole law was in the first place.
Right. The whole idea was like, if you're going to pass this for abortion, we're going to pass it for guns.
Right.
And, sort of a spite move.
A tit for tat kind of move. And Benitez basically said, look, that's not good enough. Just having your word that you're not going to enforce it doesn't mean that this isn't a controversy, and it's not having an ongoing chilling effect on litigation, as you pointed out. That's really discouraging to gun groups trying to make constitutional claims if they think that even if they're mostly successful, they're on the hook for a bunch of fees. So he said,
and it has had that exact fact.
Yeah,
because there have been gun rights groups that have pulled out of certain cases They're basically prioritizing cases they are far more sure they'll win, and they're paring down what they're claiming in those cases. So it is having a literal practical effect, a chilling effect.
Yeah, exactly. And that's essentially what Benitez's argument was. And he said, this isn't moot. We're going to let this litigation go forward. We'll have an injunction hearing on it. And in the interim between that ruling and the injunction hearing, you actually had Attorney General Rob Bonta come out and say that he will no longer be defending this law because of his previous statements that he's made about the corollary law in the Texas abortion case, where he
said it was unconstitutional.
Called it flatly unconstitutional. So now that he's tasked in his position with defending a law that he's called unconstitutional, he said, I can't do it. I'm stepping out of the case. And I guess someone from the governor's office is going to step in now to try to defend the law.
Yeah, that's definitely an interesting development. It's not very common that an attorney general is going to recuse themselves from defending a law that they've called unconstitutional in the past. It does happen sometimes, right? The government will sometimes abandon defense of various laws. You've seen this occur in the past at the federal and state level. Usually, though, it's because the law had been passed by, a different administration, and they don't agree with it politically. This time, it was passed by Democrats in California, and at the urging of the attorney general, even though he clearly knows it's not constitutional. And so it's interesting to see that play out in court to where he can't even defend the law because of this. And we'll see how well they succeed. They've been trying to just short circuit this whole thing by saying, well, we're just not going to enforce this provision. But I mean, I could see why a federal judge might not find that to be a convincing argument. Well, all right, we're not going to enforce it right now. A lot of judges have taken that to this point to be, good enough that if the state says they're not going to seek these damages, then that's fine. We don't need to litigate this. You've seen that a couple times now in other cases. And, I guess Benitez is not taking the same position because, clearly the law being in effect is having a chilling effect on gun litigation in the state, which I think should concern federal judges and, lawyers associations alike. I mean, this doesn't just make plaintiffs, the actual plaintiffs, liable for the fees. It makes their lawyers liable too, which is a pretty radical thing. A lot of stuff came out of that Texas law and California copying it that, in hindsight, you wonder if the supporters of the Texas law really thought this through very well, because the Supreme Court was on the verge of striking down Roe v. Wade anyway. And, the practical effect of that law is basically nil, while the legal effect of it and the way that it's cascaded out to be like a tit for tat approach elsewhere is obviously extremely negative. So anyway, I think that's all we've got for you this week. If you like the show, please share it with your friends and loved ones. Please give us a rating on whatever app you're listening to this on, or a like on YouTube. We post clips of the show on our YouTube channel as well, if you want to check those out, just to get a quicker taste of what we've talked about each week. And you can also, of course, go over to thereload.com and buy a membership today if you want to support the work that we're doing and get exclusive access to hundreds of pieces of analysis and reporting you won't find anywhere else. And you also get access to this podcast a day early and the opportunity to appear on the show. We have a member who's already volunteered to come on an upcoming episode. So looking forward to that. But, head over. We're 100% reader funded, and we rely on our members to make this all possible. So if you want to keep the reload going, that's how you can do it. Of course, you can also sign up for our free weekly newsletter if you want to get a taste of the kind of reporting we deliver before you make that leap. But that's all we've got for you this week. We will see you again real soon.